Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, we have an announcement. Byjus Exam Prep IAS has already started its prelims test series. For those of the students who have registered to the prelims test series, please note that this week's PTS would be Indian economy on 18th of December Sunday. So for those who have subscribed to this test series, please do give the test. Let's get started and look into the first article. The first article says reflections on the fading principle of non-intervention. Let us try and understand what is this article all about. This article here is primarily speaking about separation of powers. It also looks into judicial accountability, activism, overreach, adventurism of the judicial setup and the clear picture of separation of powers. What is the context? We have the President of India and the Vice President of India who have spoken about the significance of the separation of powers in the Indian Constitution. We have the President who went on to say the Constitution outlines a map for good governance. The most crucial feature in this is the doctrine of separation of functions and powers of the three organs of the state. It has been the hallmark of our republic that the three organs have respected the boundaries set in place by the Constitution. It is understandable that in the zeal to serve the best interest of the citizens, one or the other may have been tempted to overstep. Yet, we can say with satisfaction and pride that the three have always attempted to keep boundaries in mind while doing their best to function in the service of the people. This was the statement made by the President of India on the Constitution Day, which was held on November 26th. Then we have the Vice President as well. The Vice President also spoke about the doctrine of separation of powers, where he went on to say that democracy blossoms when its three facets adhere to their respective domains. The sublimity of the doctrine of separation of powers is realized when legislature, executive, and judiciary optimally function in tandem and togetherness. Any incursion by one, howsoever subtle, in the domain of the other has the potential to upset the governance apple cartel. He further went on to say this historic parliamentary mandate was undone by the Supreme Court on October 16, 2015 by a majority of 4 is to 1, finding the same as not being in consonance with the judicially evolved doctrine of basic structure of the Constitution. Stating this to be an unparalleled development in democratic history, he added, we need to bear in mind that in democratic governance, basic of any basic structure is the prevalence of the primacy of the mandate of the people reflected in the parliament. Parliament is the exclusive and ultimate determinative of the architecture of the constitution. Taking these two, the article goes on to say that fundamentally, when you look at president as well as the vice president of the country, they have to be above the politics. So in this particular backdrop, the author goes on to say that these statements made by the vice president with respect to the NJAC and the Supreme Court will not fall in line with the constitutional ethos, says the author. But our discussion primarily would be with respect to the larger area of separation of powers. What is this separation of powers? We have the legislature, executive, and the judiciary. They are three organs of the state. We have the legislature, which will make the laws. We have the executive, which will implement the laws, and the judiciary, which will interpret the laws. There is clear-cut separation of powers when it comes to all these bodies in United States of America. But when it comes to India, what we have is the overlapping jurisdiction with respect to the legislature and executive. What do we mean by it? When we speak about separation of powers in United States of America, it is the US Congress which will make the laws. So the laws are made by the legislature. When it comes to USA, you have the president, the executive, they implement the laws. In judiciary, they interpret the laws. But in India, what we have is the overlapping jurisdiction, which means to say the executive are the people who are elected from the legislature. So if they have to become part of the executive, for example, minister or the prime minister, they first will have to become the MPs in the parliament, and after becoming the MP, they go on to become the executive. So in India, what we have is the overlapping jurisdiction with respect to the parliamentary mode of democracy. So this is what is called a separation of powers. Why do we have the separation of powers? That is to have a clear-cut checks and balances. Let's say, for example, the legislature are supposed to draft the laws, the executive are supposed to implement the laws, the judiciary is supposed to interpret the laws. What if the legislature has drafted the law, the executive which has to implement the law is not working in line with the legislation? In that case, the legislature can keep a check on the executive's action. It can question the ministers. It can bring in urgent important matters before the parliament and keep a check on the actions of the executive as well. And at the same time, if there is a law that is drafted by the legislature and it is not meeting the spirit of the constitution, such a law can also be declared as unconstitutional by the judiciary as well. So basically, this idea of separation of powers is to keep a check and balance on all three organs of the state. Let's look into the history. This concept was first seen in the works of Aristotle in 4th century BCE, wherein he described three agencies of the government as General Assembly, public officials, and judiciary. In the ancient Roman Republic too, a similar concept was followed, but in modern times, it was 18th century French philosopher Montesquieu who made this doctrine a highly systematic and scientific one in his book De L'Esprit des Lois, The Spirit of Laws. His work is based on understanding of the English system, which was showing a propensity towards a greater distinction between the three organs. The idea was developed further by John Locke. What is the purpose of separation? The purpose of separation is to prevent abuse of power by a single person or a group of individuals. It will guard the society against the arbitrary, irrational, and tyrannical powers of the state, safeguard freedom of all, and allocate each function to the suitable organs of the state for effective discharge of their respective duties. So this basically prevents one party to concentrate all the power in its hands, so that if this continues to happen, the people are the major sufferers at the hand of one particular organ of the state. In order to make sure that this arbitrariness, irrationality is out of the picture, there has to be a check and balance. So what we have is different organs of the state. What is the meaning of separation of powers? Separation of powers divides the mechanism of governance into three branches: legislature, executive, and judiciary. Although different authors give different definitions, in general, each organ should have different persons in capacity. One organ should not interfere in the functioning of the other organs. One organ should not exercise a function of another organ. This is the meaning of separation. So legislature will basically draft the laws, executive will implement the laws, and judiciary will interpret the laws. What is the significance of the doctrine? Keeps away autocracy, safeguards individual liberty, helps create an efficient administration. Judiciary's independence is also maintained and prevents the legislature from enacting arbitrary or unconstitutional laws. So there is a clear-cut check that the judiciary has on the legislature and executive. The legislature has a check on the executive, and executive indirectly also has a check on the judiciary as well. And at the same time, the parliament, if they so decide, they can also impeach or remove. Impeach is the word that is generally used for the president. Removal is the word that is used for the removal of the judges. So for the removal of the judges, parliament would also be able to initiate the process as well. Now what we have to focus is on the constitutional status of separation of powers in India. Article 50. This article puts an obligation over the state to separate the judiciary from the executive, but since this falls under the directive principles of state policy, it is not enforceable. Article 123. The president, being the executive head of the country, is empowered to exercise legislative powers in certain conditions. Article 121 and 211, they provide the legislatures cannot discuss the conduct of a judge of the Supreme Court or High Court. They can do so only in the case of impeachment. This is generally for the president, but it is removal for the removal of the judges. Then we have Article 361. The president and governors enjoy immunity from court proceedings. Then we have the judicial review, where the actions of the executive and the legislature can be taken up. Judiciary has the power to strike down any law passed by the legislature. It can declare unconstitutional executive actions as void. Legislature also reviews the functioning of the executive. Judiciary is independent. Judges are appointed by the executive. The legislature can also alter the basis of the judgment while adhering to the constitutional limitation. Let's say, for example, we have the Supreme Court, which has declared one of the laws as unconstitutional. So the Supreme Court has declared it as unconstitutional. Despite this, if the Parliament so decides, it can bring changes to the existing law and can continue to persist with the law as well, is the final point. What have been the various judgments of the Supreme Court with respect to the separation of powers? The Honorable High Court in Ram Javaya Kapoor vs. State of Punjab held that Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, which is what we discussed initially, but the functions of different parts or branches of the government have been sufficiently differentiated, and consequently it can be very well said that our constitution does not contemplate assumption by one organ or part of state of functions that essentially belong to another. Then in Indira Nehru Gandhi versus Raj Narayan, CJ observed that in Indian constitution there is separation of powers is a broad sense only. A rigid separation of powers as under the American constitution or under Australian constitution does not apply to India. The court further held that adjudication of a specific dispute is a judicial function which Parliament, even acting under a constitutional amending power, cannot exercise. Then in Kannadasan versus the state of Tamil Nadu, it was held the constitution has invested the constitutional courts with the power to invalidate laws made by Parliament and the state legislature transgressing constitutional limitations. Where an act made by the legislature is invalidated by courts on the basis of legislative incompetence, the legislature cannot enact a law declaring that the judgment of the court shall not operate. It cannot overrule or annul the decision of the court. But this does not mean that the legislature, which is competent to enact the law, cannot re-enact the law. Similarly, it is open for the legislature to alter the basis of the judgment. It is in this particular backdrop there have been some issues with respect to the judiciary. What is it? One is to do with judicial accountability. Second is to do with judicial activism turning into judicial overreach or judicial adventurism. What is this judicial accountability? When we speak about judicial accountability, we have the legislature which is keeping a check on the executive. How? There are questions that are asked. The media is constantly questioning the executive, and in all the debates and discussions in the parliament, the ministers are also kept a check by the members of the parliament. But this is not the same when it comes to the judiciary. You cannot speak about how the working of the judges are, and at the same time when it comes to judicial accountability, the word originally given in the constitution was consultation. This consultation was made equivalent to concurrence, and nowhere in the world is judiciary appointing its own members, but in India it is the collegium system which is appointing judges on its own. So how are they appointing? Why should there not be a process? In fact, the NJAC was declared unconstitutional. So where is the judicial accountability? So when we have the legislature which is being questioned by the people every 5 years, the executive are constantly kept a check by the legislature, who is keeping a check on the judiciary. How is the appointment process happening? So where is the judicial accountability is the crux of this article. Next point we have to focus is on judicial activism. What is this judicial activism? Let's say, for example, we have number of guidelines that have been given by the Supreme Court of India. Let's say when it comes to the sexual harassment at workplace, we did not have the laws. So what did the judiciary do? The judiciary over the court of the legislature and came up with what is called as the Vishaka guidelines. When you look at issues that are persisting in the society, you would feel that whatever Supreme Court did was right. But when you look at the larger picture of separation of power, powers, why did the Supreme Court wear the coat of the legislature and come up with these guidelines? Ideally, the role of the Supreme Court is to accept and interpret the laws, but it is not for the Supreme Court to come up with guidelines, so on and so forth. So the first thing is judicial activism, which is good for the country, where Supreme Court has owned the court of the legislature. It has given guidelines, but at times this has led to judicial overreach. This is what is called as judicial adventurism, where they were not supposed to do that, but they have committed an act of the legislature, which means the clear-cut separation of powers that we have is violated by judiciary at times. So this article also indirectly points out that because there is no judicial accountability, because this National Judicial Appointments Commission was declared as unconstitutional, how is that the legislature and executive can keep a check on the judiciary, and the judiciary declared such a legislation as unconstitutional? So we have the president and the vice president speaking about the doctrine of separation of powers, but the author feels though the intent and the idea is good, but the president and the vice president should be apolitical people, and they should not have drawn this inference, especially with respect to the wordings of the vice president, is what is this article all about. Now let's look into the next article. This article says, is the RTI Act fulfilling its purposes? The article here is speaking about the Right to Information Act. What is this Right to Information Act? What are the various processes that have to be followed for the Right to Information Act? What have been the achievements? What have been the disturbing factors? How do you go about filing an RTI? What have been the major obstacles and impediments? Have all been discussed as part of our knowledge series. So all that you have to do is look for Right to Information video in our Byjus IAS channel. We will not be discussing what RTI is all about, but we will try and understand what have been the advantages of right to information as to what is given under this article, and we will also focus on some of the major challenges for the effective implementation of the right to information. First point that we have to focus is about the achievement or some of the major outcome of the Right to Information Act. The first advantage or the pros of the Right to Information is it gives an obligation on the government to respond to all the applications filed by the people in a time-bound manner. What do we mean by it? Let's say, for example, if people wish to get some information about a particular scheme and program, or about the implementation of a particular welfare program, in all these cases, what do? They file an RTI application. The minute they file an RTI application, within a particular period of time, they have to give this information. Earlier, there was no transparency about this particular scheme. There was no transparency about this welfare program. But now, if there is a major issue that a welfare scheme and program is not reaching the intended beneficiary, in that case, they would be able to file an RTI and they would be able to extract an information, and this information will have to be given in a prescribed manner within a prescribed time period. If they do not do so, that person from whom the information is sought, that person will be imposed with penalty as well. So the first advantage is, if you require an information from a public authority about a public welfare scheme and program, they have to give it, and this is in a time bound manner. The RTI has also been able to expose big ticket scams such as the Adarsh, Commonwealth scams and the Vayapam scams. And filing of RTI is a simple process. It is not a rigid and a hard-some process. In fact, it is so simple that they would also be able to extract the information from that particular department. So there would be some questions that you have to ask, and these questions will be answered by the Public Information Commission, and at the same time, this process is very simple and not complicated. But if it is about, let's say, a complex project, it is about a larger scam which will have its own share of manifestation, cases of violations of law or human rights. In that case, the questions that are asked by the people will also have to be on a larger, broader level. This may become complex. So at such points, what you require is an expertise. But for normal welfare schemes and programs, if it is about asking for the ration card, if it is about a particular beneficiary of a particular program, then in that case the complexity is not present, so one would be able to ask the questions and get their answers. So these are some of the advantages as given under this article. But what are the major challenges when it comes to the right to information? The first happens to be the lack of awareness. Many people do not know how to file this right to information act. People do not know that they can exercise such an option, so an awareness has to be created for the people. Second is the liability on the applicant to find out which officer and which office will hold the information. Of late, the public information officers have also become very intelligent. How? They are not giving information. Let's say, for example, there is a person who wants an information from one of the departments. Ideally, when this person points out that this is the information that is wanted from this department, the public information officer will have to give it. What if this information is not in that particular department? So he has to route it to another department. But this is not happening. Instead, he says that this is the information which is not available under our department and rejects this particular application or sends it back. In this case, the onus or the responsibility for finding out which department it belongs to, what information, where it has to be sent, will all be have to be reconfigured, reinterpreted, will have to be discovered by the person who's filing an application. Ideally, the public information officer will have to route it to that particular department wheresoever the information can be extracted. But because they do not want to divulge the information, give out the information, they ultimately reject this or give it back to the people, saying that they have no idea. It is their responsibility to discover which department that this particular query has to go. The third is with respect to data sets and information. What do we mean by it? Let's say, for example, we have an issue. We do ask a question to the government. But what if the government does not have the information about such a thing? Let's say during the COVID-19 period, the government was asked a simple question via the right to information as to how many people passed away because of the COVID-19. But the government did not have the data. So what would happen during that period? So maintaining data sets and information is the onus and responsibility of the government. But if the government does not have, the essence of this law is again lost. Another important factor is about 2021 census. The government is saying that it has postponed the census for a indefinite period. So the government which has to collect the data, when it will be coming out with it, is again not known. That is another major issue. The fourth is with respect to the file notings. What are these file notings? These are the notings or observations made by the bureaucrats on the contents of the document. Ideally, these file notings should also be part of the information under the definition of the RTI. But the government in number of cases has said that this file notings information is something internal for a department as well as for the bureaucracy, and they have declined to give this information. So file notings will not be part of the right to information, said the government in number of cases. Then we have political parties. According to the legislation, political parties are not public authority, so one would not be able to seek any information from these political parties. What are the sources of their revenue? How are they generating a lot of revenue? This information will not be given by the political parties because according to them, they are not the public authority. So they want to create an opaque process, but they want transparency from the people in and around the country. And finally, we do have a lot of vacancies in the information commissions as well. Ideally, when information is sought, it is the information commission officers who have to fulfill these duties and give us the information, but enough number of people are not there. There are large scale vacancies that are present, and ultimately appeals and complaints keep pending, and we do not know what exactly is the status of information that we have sought out for. So basically, when we look at RTI, it has its own share of successes, failures, challenges as well. So can we say it has fulfilled? To a certain extent, yes, and to a certain extent, no as well. And recently the government has also brought in a lot of amendments as well. This has hit the right to information's backbone, and ultimately certain issues will have to be addressed, is what is this article all about. Now let's look into the next article. This article says, what are Kerala's universities laws amendment bills? Let us try and understand what is this article all about. When we look into the Kerala's university laws amendment bills, this was primarily introduced because there was a lot of misunderstanding and at the same time issues between the governor as well as the cabinet. In order to address these issues between the governor and the cabinet, Kerala University's laws amendment bill was brought into picture. What is this legislation all about? Earlier, we had the governor who was the chancellor of all the state universities in the state of Kerala. Now, this particular bill that is introduced in the state legislature of Kerala goes on to say that the government would be able to appoint one of the chancellors as the chancellor of the university, and the governor as the chancellor of the university will no more be present. He will be removed from this particular position. So the proposed legislations will amend statutes of 14 universities established by the legislative acts in Kerala and remove the governor as the chancellor. The bill will give the government power to appoint eminent academicians as chancellors of various universities, thus ending the governor's watchdog role in the university administration. How did the bill come into being? That is because we have the governor and the state governments who have been at the loggerheads. They have had disputes for a couple of times, and as a result, the Kerala government now feels that the governor is interfering with the affairs of the state, and they have come up with this particular initiative. What is the basis of coming up with this legislation? We have the Punchi Commission. The Punchi Commission went on to say, we have the governor. The governor has its roles and responsibilities, and he is also given certain duties as well. Are these duties mentioned in the constitution of the country? If it is mentioned in the constitution, then that particular role, authority, duty should be given to the governor. But if such authority and power is not given in the constitution, described in the constitution, then the governor should not be given such power. So according to the Kerala's legislation that they have come up with this particular bill, they basically went on to say that since Punchi Commission has this particular recommendation, we should not be burdening the governor with extra load or work, and that is the primary reason they have removed the governor as the chancellor of the university. So the burdening the governor with positions and powers which are not envisaged by the constitution, which may lead to the office of controversies or public criticism, was the rationale behind the bills. This is the primary reason the Kerala government has come up with this legislation. So what is the controversy that is associated with this particular bill? There will be no checks and balances when it comes to the chancellor. As of now, you have the chancellor, which happens to be the governor. The governor can look into how the universities are. Now, with all the appointments being made by the government, these people, the chancellors, will have to reciprocate back to the government. So they will not question the government, and the autonomy will be facing a stake, and the independence will be facing a stake, as there will be constant interference by the government as well as its appointees. So the major issue right now is that once the governor is removed from this chancellery position, what we will have is these political appointees who can become the chancellors of that particular university. They may not question the government, and ultimately the independence will also go out. There will be interference by these political parties and the government, and ultimately education could be at stake, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says public servants can be found guilty of graft on circumstantial proof, says the Supreme Court of India. This article here is speaking about bribery. When we speak about evidence, what we have is different types of evidence. One is what is called as oral evidence. Second is what is called as documentary evidence. Third is what is called as direct evidence. Fourth is what is called as circumstantial evidence. What is this oral evidence? Let's say, for example, I am speaking to you, and I, as a person who's seen something, I have witnessed a murder happening right in front of me. I go to the court of law, I give the oral evidence. I say that yes, I did see this particular person A murdering B. So this is the oral evidence. I would have seen something, I would have heard something, I would have felt something. So I go to the court of law in front of the judges when I'm being asked. I go and say it orally and give a description of it, which is called as the oral evidence. Second, what we have is called as the documentary evidence. What is this documentary evidence? How do I prove that I have cleared 10th standard, I have finished my 10th standard and I want to apply for a particular job? I have to give the 10th standard marks card. How do I prove my age? I have to give my 10th standard marks card. So for certain things, this person cannot orally say it, but will have to prove it via the documents. That is what is called as documentary evidence. The third is what is called as the direct evidence. What is this direct evidence? Here I have seen a person committing a murder. So I have been a witness to this particular incident. I have seen it directly. So there is no inference that needs to be drawn, because I go to the court of law, I say that it is A who committed B. I say to the court of law, yes, it was this person who was driving the car, it was this person who took the car on the footpath and ultimately killed a particular person. So I have seen it, so I go on to confess this information because I have seen it literally. So this is what is called as direct evidence. Then we have something called as circumstantial evidence. What is this circumstantial evidence? Let's say, for example, there is a premise where A might have killed B. We do not know, we are just assuming that A might have killed B. We are not saying that A has killed B. But what exactly happens? Previous day, there is a person C. This person C would have seen A and B having a big fight. They're throwing voices against each other. And at the same time, this person A has murdered B, is what we are assuming. And then B is murdered the next day, and A walks out of the house where his shirt is all bloodshed. He also has a knife. It can be any scenario. A might have murdered, or he might not have also murdered as well. But when you look at his shirt, there is bloodstains on his shirt. He also has a knife, and at the same time, B is also murdered as well. This is what is called as circumstantial evidence, which means to say C has not seen A murdering B directly. He did not see it via his eyes. But what he has seen is that A is walking out of that house. He also has a knife as well. So this is what is called as circumstantial. So we have not seen it directly, but we can draw an inference that the previous day they did have a fight, that this person had a knife in his hand. So directly he might not have seen it, but because of the situation, because of that particular circumstance, we would be able to draw a reference, is what is called as circumstantial evidence. Why are we discussing about all this? That is because in this particular case, the Supreme Court went on to say, if there is a case of bribery, that is a public servant, if he is asked for money from one of the persons, if there is no oral evidence, if there is no documentary evidence, if there is no direct evidence, in that case, circumstantial evidence can also be considered to make sure that this person who is asked for the bribe, the public servant, should also be penalized. So if the prosecution has the circumstantial evidence to prove that this person might have been involved in this bribery case, so prove with the circumstantial scenario. If you are able to prove so, then this person will be culpable under the Prevention of the Corruption Act, and ultimately he would be penalized as well. So it is not just oral evidence, documentary evidence, direct evidence. If you do not have any of these, if you can prove to the court of law that circumstantial evidence proves that this person has committed so and so act, in that case, what we would able to prove is that this person can be thrown behind bars. So the Supreme Court went on to say that there are two ways of introspecting it. One is what is called as acceptance. What is this acceptance? When it comes to acceptance, what exactly happens? The person might not have asked the money. So this person, that is the public servant, would not have asked for the bribe, but the other person might have offered it. this person, public servant, would not have asked for it, but if he accepts despite not asking, that is what is called as acceptance. Then what we also have is called as obtainment. What is this obtainment? Obtainment basically is that the public servant would have asked for the bribery, the person would have accepted it as well. So when he is asked for it and he has accepted it, that is what is called as obtainment. He is not asked for it, but he has accepted from this person, that is what is called as acceptance. So in this particular backdrop, if the prosecution is able to prove any of these scenarios, even with circumstantial evidence, then we can accept it and make this person culpable under the Prevention of Corruption Act, is what is this article all about. And further, you can also use such words as the fodder in your mains examination. What is it? We have the Supreme Court Judge Abdul Nasir, who went on to say about corruption that corruption is the stink of corruption, has a pervasive impact on the efficient administration and governance of the country. Corrupt officials have a demoralizing effect on honest public servants. Corruption by public servants has become a gigantic problem. Large scale corruption retards nation building activities, and everyone has to suffer on that count. These are some of the wordings given by the judge of the Supreme Court, and if you wish to, you can use these words and quote it in the examination as well. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says China builds ropeway roads near tri-junction. The tri-junction is between India, China and Bhutan. So China has set up a ropeway near the Tors Nala on its side of India Bhutan China tri-junction and is strengthening roads and other infrastructure along the entire eastern sector. So this article currently goes on to say that China has been building roads, improving the infrastructure. So in case of any trouble, it is able to access this infrastructure and the road and lead to that particular place and ultimately help in its connections to this particular place. So we have discussed about what exactly happened in Tawang recently. We did also discuss about what are the various issues, what lessons India can draw from it, what is the way forward in our previous CNAs as well. All that you have to understand right now is that China is planning to build the infrastructure in this part. For the rest of the analysis, you can look into our yesterday's CNA. Now let's look into the mains practice questions. Do you think that the Constitution of India does not accept the principle of strict separation of powers? Rather, it is based on the principle of checks and balances. Explain. Next question. Is the RTI ensuring transparency between the citizen and the government as it was intended to do? Critically evaluate. So please write all your answers on the comment section. And if you wish to upload an image, you can also do so on our free IAS prep website. So this is it for today. Thank you for watching. All the best.